Hello, everyone, and thank you for joining us here today. My name is Gene Quinn. We're going to get started here momentarily. We'll just let people get from the green room, Zoom's green room, into the webinar room. So we'll start here in just about 15 seconds or so. So just bear with us for a moment, and then we'll be off to the races. Okay, it looks like our numbers are plateauing for now. I'm sure we'll get more people joining, but we can get started. Excuse me. Welcome, everybody, and thank you for joining us here today. My name is Gene Quinn. Appreciate you spending a portion of your day here to talk about this very important issue. We just got into a pretty heated conversation. I think vehement agreement is probably the right way to say it in the green room leading in. So we're going to have, I think, a hot panel for you here today. We're going to be talking about cutting pendency, which then requires us to talk about the current backlog at the patent office, why that happened, what's happening now, what are the projections moving forward. And then we're finally going to talk about, well, how does one then use tools that are available to get faster, stronger filings and faster, quicker patents as well. So with that brief introduction, let me kick it over to Renee to introduce our speakers. Renee.
Thanks, Jean. On our panel today, we have Bob Barr. He's a partner at Meyer & Meyer, PLLC, where he advises clients on all aspects of patent law, from prosecution and litigation strategy to USPTO policy and procedure. Before joining private practice, he served as the Deputy Commissioner for Patent Examination Policy at the USPTO, where he helped shape nearly every major patent rulemaking since 1995, including the AIPA and AIA. A recognized authority on patent laws and procedures, Bob brings deep expertise gained from decades of leadership and innovation within the U.S. patent system. Next, we have Joe Manico. He began his career at Eastman Kodak in 1975, where he helped develop groundbreaking technologies in digital imaging, cameras, displays, and printing systems. As one of the primary contributors to Kodak's patent portfolio, which was later sold for $525 million, he played a pivotal role in advancing Kodak's innovations. Today, as an innovation consultant with Kodak, Alaris, Joe continues to guide research teams in protecting and maximizing the value of their intellectual property. Next, we have Jim Durkin. He's a former USPTO patent examiner and managing director of product management at IP.com, where he works directly with clients across the globe and IP.com's development team to enable AI assisted workflow solutions related to IP.com's insight reports, as well as IP.com's innovation discovery and AI driven search platform, Innovation Q, and its flagship prior art database for defensive publication. He is a registered patent attorney, inventor, and former primary patent examiner for the USPTO in the area of graphical user interface with a BS in computer science. And last but not least, we have our moderator, Gene Quinn. He's a patent attorney and a leading commenter on patent law and innovation policy. He founded IP Watchdog in 1999 and since has twice been named one of the top 50 most influential people in IP. He's regarded as an expert on software patentability and U.S. patent procedure and has repeatedly been recognized as one of the top IP strategists in the world. So you're in great hands with this panel. Back to you, Gene.
Great. Thanks a lot, Renee. And again, thank you all for joining us here today. What I'm going to do is I'm going to go around the panel, and we can go in the order in which Renee introduced you so that we can get your preliminary thoughts on this important topic. So Bob, let's start with you. I know you're not at the patent office anymore, but you were front row center for much of what we're about to talk about, particularly once we get to the slides that we have. So I'm really anxious to hear your preliminary thoughts on this topic.
Sure. Thank you, Gene. So stating the obvious or a little background is I'm going to look at it not so much from the viewpoint of how many applications, unexamined applications are pending, because that doesn't tell the story in and of itself, because it depends upon how much examining firepower you have. Is the factor of whether or not a backlog is just an inventory or it's a backlog. The number I tend to focus on is first action pendency, which if you look at the PTO's charts, has gone from about a little less than 15 months pendency to first action to over 22 months. And that's over the last 5 or 6 years. And that's a significant rise in first action pendency that is, to put it mildly, a little concerning. So to ask me what I would do to address pendency, that you kind of have to look in different time frames. The first, if you want to address it in a short time frame, you do things like you basically put everyone back to work. It's basically all hands on deck. You cut down, as I believe the PTO did, is on what they call other time, examiners doing things other than examining. The second best thing, well, I would say the best thing to deal with pendency is to have hired examiners consistently for the last 5 years. Of course, the problem is forward looking, you can hire examiners. It doesn't really pay off for 3 to 5 years. It would be nice, though, in my opinion, if the PTO had consistent hiring over the years. I think that's better than hiring a lot of examiners and then not hiring examiners and doing that over and over again. So basically, in the mid time frame, hiring examiners is the way to deal with it. But I think really looking at this, unless you want to take a lot of engineers offline and have them examining patents, for the future, you really have to change how the patent office examines applications. And I'm going to say, stating the obvious to this panel, the PTO basically has to adapt its examination practices to more integrate AI into the process, both in terms of searching and applying rejections, basically focusing on, cutting out the decisions that can be, or the issues that can be resolved, using AI, and focusing examination on the issues that need to really be decided by a human. And so those are sort of my thoughts on the patent examination process with respect to the backlog and how it really needs to be addressed, and I'll call it the longer term future.
Great, awesome. Thanks a lot, Bob. Joe, your preliminary thoughts on the topic.
Well, as a user of the system, you can do a lot to make some of this go away just by using a tool like Semantic Gist in order to do a real good prior art study internally. So when you do file your patent and you're not surprised by what the office action looks like, things go a lot faster. It's very rare that I'll have an office action where I'll see a piece of relevant art that I haven't seen before. And I think that would really help expedite the process if you're providing an application that has a very high chance of issuance because you've done your homework up front.
Okay, awesome, good. And Jim, last but not least, your preliminary thoughts.
Yeah, just building on what Joe's saying, I feel like there's a lot that you can do to proactively make a difference. Now, you might not be able to impact the first office action pendency, but you can help in terms of bringing down the total pendency based upon the quality of the search that you do ahead of time, the claims that you end up drafting, and the strategy that you approach with patent prosecution. And I think that can make a big difference in terms of the overall pendency. Also, you can consider, how long it's taking you to even get to these filings as part of the process. So I would encourage everyone to think about it a little more broadly. Think about how long it takes you to go from your first idea to the patent application to the allowance, and think about that whole pipeline.
Awesome, great, thank you. Now, if anybody has any questions during the rest of the panel, please put them into the Q&A box. I'll be monitoring the Q&A box. If you have any questions for tech support or very specific questions of IP.com, you can put them, excuse me, into the chat box. I'm not likely going to be able to monitor the chat box and the Q&A box and the panel. So if you want something for the panel, please do put it in the Q&A box. Now, with that, let me share my screen because I know, Jim, you've prepared some slides that you wanted to go over. Can you see those?
Yes.
Okay. You want to go ahead and tell us what it is that we're looking at?
Well, the first, you can see the USPTO backlog going from about 500,000 up to 800,000 today. You can notice a period where it was relatively flat. You would notice there was an impact during the COVID era, likely from some of those restrictions that were placed on the examination office. But you can see For example, the strategic plan that they were doing around 2014 to 2018 to reduce dependency and backlog, keeping that number relatively flat. And you can see it's going up right now at about a 3.76% rate. Then if you look at unexamined patent applications, you can see that if we were to project this out to 2035 with nothing changing, it would exceed 1 million applications. And then this is what I was mentioning a little bit earlier in the introduction. You can look at these pendency statistics. We're at about 22.8 months for first office action pendency. And curiously, if you look at traditional total pendency, that's remained relatively flat, even though you've seen a change from the 2015 to 2025 in terms of that first office action pendency. And then taking a look at this is just a projection showing that there's a potential, if the first office action pendency continues to go up, that it could force the traditional total pendency to grow beyond the current levels. And this is just assuming nothing changes, which I'm not sure is necessarily, 100% realistic, but this is just a kind of what it looks like from the projections.
Okay, so before we get into this stuff, let me go around the horn with Bob and Joe to get your thoughts. Bob, when you look at these numbers, what do you think is happening here? What do you think is likely to happen?
Well, I'd like to think that the back file of unexamined applications wouldn't go over 1 million. But I will, sorry. But I mean, certainly the charts are, they're really, you can't argue with them. It looked like the back file grew by 300,000 applications, and I don't think it's unrealistic to think that they could grow by 300,000 more applications in 10 years. And I will say that historically, total pendency is generally about 10 to 12 months higher than first action pendency. So stating that in a different way, the first action pendency tends to drive what the total pendency is going to be. Whatever the first action pendency is, the total pendency tends to be 8 to 10 months. I'm sorry, 10 months to 12 months higher. Here you can see it's actually closer in time. This is a little unusual, but if someone can flip to the next slide, if first action pendency stays at 22 months for any length of time, total pendency is going to be 30 months. It makes perfect sense. In fact, it's a little surprising it's not that sooner.
So I was thinking that too, Bob, because when you look at this, I mean, how is that? Is it just like there's so many that are giving up after the first action that's pulling down the total pendency number?
That could be. At first, when I saw this, I was thinking there was just a lag, but pendency's been up over 20 months to first action for the last few years. So it really can't be explained by a lag. Now, also, when the PTO calculates total pendency, it takes into account both issued patents and abandonments. I think that the pendency of a case that resulted in an issued patent is going to be higher than average, whereas a case that was abandoned is going to be lower than average. So the pendency as felt by a successful applicant is probably going to be higher than this.
Yeah, that would be an interesting number to take a look at and see. I have some thoughts, but I'd like to get Joe your thoughts before I go on a rant. You're on mute, Joe.
I can't help but think that some kind of AI front end at the USPTO to kind of sort through the applications that it receives, and kind of like the wheat from the chaff. There's going to be many applications that are just not going to issue, and if you could have or they're incomplete or there's no prior art search, those could seem like the AI can filter through those, and those could be dispensed with quickly. And I don't know if that makes sense, but it does seem, I know, again, using AI tools can help go through documents really quickly and sort through them and engage them against the prior art before a human even sees them.
Yeah, I think that's going to be a solution. We're going to come back to that here some more in a moment. What I just want to give my thoughts, like when you look at this, there is every reason to believe that these numbers are going up. Now, I do realize at the end of the Biden administration, the number of unexamined patent applications had gotten to about 840,000. Not quite, but almost. And so over the last, what is it, 9 months or so, we've had probably 9+ months with under the Trump administration, it's decreased by about 40,000 applications. So the Patent Office is trying to lean into this. There is a limit, though. Rather than hiring all the examiners that they wanted to hire, they had to withdraw those offers, and they did get allowance to hire, but they only have so far, I think, hired several hundred. They had to withdraw 600+ offers at the beginning of the Trump administration as a part of nothing to do with the Patent Office. It was just a broader effort to reduce the size of government that the Patent Office gets wrapped up into. So there's a lot of moving pieces and parts. Some of them are outside the control of the patent system and are more government, whether you like it, whether you don't like it. They're not issues that affect the Patent Office specifically. They're issues that affect all government. And those are issues that are going to be tough to be pulling away from, because for whatever reason, the powers that be don't seem to really appreciate that the Patent Office is self-funded. And that's a different conversation for a different day, but it is the plight that we're in. The thing that I see when I look at this, and I wish I could just almost like shake the industry and get them to pay attention, because I've been beating the drum on prosecution laches now for at least the last several months, but much longer historically, but really hard over the last several months. Because the Federal Circuit has a rule that says that if it takes you 6 years or longer to obtain a patent, it is presumed to be on enforcement. And the way that the presumption works is that prosecution laches, which is a doctrine that's been around for a while, says that if it takes too long to get it, if it's an unnecessary length of time that the patent applicant inserts into the prosecution, then laches can apply. And what the Federal Circuit has said most recently is if it's 6 years or more, the unreasonableness is presumed. And then the burden shifts to the applicant in order to demonstrate that it was not unreasonable length of time that they used. So now we all know that the big case at the moment right now is Gil Hyatt. And people are saying, oh, well, it deals with Gil Hyatt, you know, bad actor in a lot of people's opinions. Not saying that's what I think about it, but I understand that there is that perception out there. But that rule has been applied in Google versus Sonos and other cases as well. And there's a gigantic pharmaceutical case where I think it's GSK versus Pfizer, GlaxoSmithKline versus Pfizer. And I'm 99% sure it's Pfizer that has raised the issue of prosecution laches to try and kill GSK patents, which why would a pharmaceutical company do that? It seems like the lawyers are trying to win that case and maybe lose the war, because if that happens, most pharmaceutical patents are going to go away. Now, this is a ticking time bomb, because the horrible I laid out in the green room was what happens if you have a situation where you as the applicant, there's no shenanigans. Everybody agrees there's no shenanigans in this case, but you as the applicant just take every extension that's available, including, you know, all, you know, pay for 3 months every time the response is due. Then you wait to the end of the 6-month period with after a final rejection to file a notice of appeal, and then you add plus 7 months for an extension after that to then file your continuation 13 months after the final rejection. You do that a couple times. Well, are you now, even though you're paying your fees along the way, even though you're within the timelines, are you going to be found to be acting unreasonable? And I, with great confidence, would predict that there are at least certain panels, if not a majority of panels at the Federal Circuit, that would find that to be unreasonable. Okay, the industry's not getting the message. Federal Circuit doesn't like patents. They don't want patents. They want fewer patents. They want stronger patents, sure, whatever that means. But this is, I think, a calamity. And when you look at this chart, you've got to, I think, be prepared as an applicant to use track one. You've got to be prepared to put your application in the best case at the moment it is filed. You have to, if you have something that matters, you've got to try and get it quicker, faster, stronger patents. And now segue into AI. That's where I think a lot of the solutions can come from, coupled together with track one, because you don't want to be, remember, oh, you probably had this experience in law school. What did your law professor, so some law professor told you this undoubtedly, is you don't want to be in a case book. Because if your case is in a case book, things went really wrong for your client, right? So you don't want to be at the federal circuit arguing that what you did to get your patent in 7 years or 8 years was reasonable. You just don't want to do it. Don't make the law. Get your patents quick. Now, if you're pharma, I don't know what your answer is. I think you may be screwed. So a lot there, Jim. But before we move on to the next group of slides, what say you?
Well, I agree with you, Gene. I think it's a problem, especially if you're talking about just a 6-year period, because as the backlog continues to grow, we're going to be finding a lot of people facing that situation, maybe through delays that occurred through no fault of their own, which, as you know, the point you were making earlier, that's why we have patent term adjustments to account for the delays from the patent office. So I feel like you could end up in some very unfair scenarios for people looking to enforce their patent rights where they're getting this laches doctrine applied against them. So I tend to agree with you.
Awesome. Great. So now let's move on because now we're going to start, I think, to pivot into discussion of AI. And let me launch a poll question here so we can start to get audience feedback, and then we can kick this stuff around and so forth. But Jim, what do you want to tell the audience while we're asking this particular poll question?
Well, just think about how comfortable you are in terms of patent offices using AI or agentic tools. So it's definitely something that's starting to happen right now. In fact, the USPTO leverages tools from IP.com, and other patent offices are continually adopting new artificial intelligence tools. So just think about if that's something that you're comfortable with in terms of AI being used at PTOs.
Yeah, that's the poll question I have pending now. Bob, since you were there, I mean, and I think, Jim just said it, the patent office is using AI tools. Do you have any sense, and I know you've been gone for a couple years now, but do you have any sense as to what extent, what the magnitude of use of AI is by the office currently?
I think I would still say it's sort of in the, for lack of a better term, beta testing phase. When I was there, there were certain uses of searching tools that have a more like this type feature. There was also looking into some tools that would help look at an application and see that the disclosure and the claims align, that the same terms are being used, and possibly determine which terms in the claims are means plus function or 112F type limitations. Um, but also, I'd point out that some, I'll call it late breaking news, is that tomorrow in tomorrow's Federal Register, there's a pilot program that the PTO is announcing where they would, if an applicant wants, they can file a petition saying they'd like to be treated in this pilot program, where the PTO does an AI search and gives them the search results so that they can look at them and decide whether they want to file a preliminary amendment or do anything before the case gets picked up for examination. So the patent office is still in the pilot or beta testing phase for AI. It hasn't put anything in place for all applications yet, but certainly there will come a point in time that it's not an option, where they will probably be using AI to examine applications. That's a prediction, not nothing I actually know.
Yeah, yeah. I mean, it seems pretty clear though to say, Bob, right? Would you agree? The office would like, or maybe not like, but the office is moving in that direction for purposes of investigating the feasibility.
Yes, I would definitely say that. You somewhat have to look at it as 30 years ago, when I did office actions, they paper and pencil, I wrote things out. Today they use computers, everything's done by computer. It's simply the next step that they're going to have to take to keep up with the times. In my mind, it's just irresistible.
Yeah, yeah. Okay. So let me end the poll, and I'll push the results in. We can kick around these results here. We have 10% are very comfortable. Half of you are comfortable if there's transparency. 26% are neutral. 10%, the same number that are very comfortable, are uncomfortable. And then we have a very small number of people who are opposed to it. I would not be opposed to it for sure, because I think that this is going to lead to better. And what I don't want to do is just turn this over to the machines and not have a person looking at this stuff. But certainly I think that there's a lot that the AI can do, and whether you're comfortable or uncomfortable or completely opposed, it's important. I think you do all need to understand the office is investigating this, and if it looks good, they're going, and where it produces the desired results, they're going to move forward with it. That's my prediction. I mean, I think that's pretty clear. Joe, what say you?
Well, as a user, I'm using these tools right now because I want to make sure my specification is in compliance, that the claims are supported by the specification, that I did a thorough prior art search, so I'm not going to get surprised by the office action. And it's like, are you going to go, now that you're comfortable with your word processor, are you ever going to go back to your typewriter? It's just like, once you've experienced these tools, there's no going back. And in terms of how the USPTO deploys this, as a quick filter up front, and it has some advantages too. It's the human subjectivity part of this can be removed. Where everybody's being judged by the same standards. It doesn't vary from examiner to examiner. At least that in the early stages of an examination, that these tools are invaluable. And mostly for looking up prior art and make sure that the documents are complete, and AIs are also really good at comparing documents too, as opposed to just going off and asking them to be creative. As I see these two fixed documents, compare them using the following criteria. The AIs are really good at doing that right now. So it's just a matter of integration, testing, and people feeling comfortable with it. But it's so inevitable because it seems almost perfectly suited for this application. Moving words around, comparing words. That's what LLMs do best.
Yeah, yeah, and I think the searching that I've seen, Jim, maybe you can comment on this, but the searching is actually right now already extremely good, and
Awesome.
and better than a human, really. Is that fair to say, or am I overstating?
No, I think that's fair to say. I mean, I leverage semantic searching all the time when I'm looking for kind of critical prior art. You can't just rely on traditional Boolean techniques anymore. But what's really nice about our engine is that it's a hybrid engine. So you can actually combine the power of AI search with traditional Boolean operators as an overlay and kind of get the best of both worlds. So I think, Gene, I look at AI as an assistant, and you're still going to have that manual step of having the human being involved. You're never going to be able to take them out of the equation. What you're really looking to do is empower them.
Yeah, and I think that that's the case. And what I've been told by people who use these, and maybe Joe, you can comment on this because you're the actual user, but that one of the things that makes the AI searches better is that they don't have a particular bias. And by that, what I mean is whether you're a search firm, whether you're an examiner, you're going to look at these things and say, okay, I got to search X, Y, and Z. Well, I've been in the X, Y, and Z area for a very long time. I know that the Smith reference is relevant, and I know Jones is probably quite relevant as well. So then you are constantly pounding Smith and Jones into the square hole, whether they're square or not. They're good enough, but now with these things, you might need to weave some stuff together and have a bunch of other, create a long obviousness chain of rejection. When the AI does the search, the AI doesn't have a bias because they don't know that Smith and Jones are the ones that they've been using to reject or put on search reports for the last 10 years in this space. So the AI just goes and looks for the best references. And that may include Smith and Jones, but it won't necessarily have them at the very top. And so that's one of the things that I've been told that make these searches much better. Would you agree?
Not only that, you're not using words for your searching anymore. You're searching on concepts, and that is it's huge because you might find something highly relevant that's in a whole different area of art that you would never even think to look at because you're like you said, you're conditioned around the art. Whereas a semantic search is going to look at everything at once on a conceptual basis, not on a matching word basis. So it's another level of sophistication. And then you throw the AI on top of that, where it's more like this, less like that, find more that are from this inventor. You can do all of that. in the time it would take just to put together your Boolean search, you're already now you're going after, you're now looking at results as opposed to still trying to find results. You're spending your time analyzing the data, not trying to locate it. And it's a whole different way of working. I can have someone sit at my desk, describe their invention to me in 10 minutes, and then have 3 of the most relevant references in my hand while he's talking. You can't do that with a Boolean operator. You just can't do anything like that.
Yeah. Yeah. No, well, let me push this next poll question here because this is going to start to pivot us, I think, into now we talked about searches. Now, improving the quality of the disclosure, which is something, Joe, you did also mention. And Bob, maybe I can get you to talk about this too, because I don't want to put words in your mouth, Bob, but there at times have been more emphasis from the office to try and get the industry to understand the importance, for lack of a better way to say it, of 112. And if you don't file a good, tight 112 appropriate specification at the start, it just mucks everything up. And I know the one thing examiners have complained to me the most about over time is the 112 errors at the time of filing. They all hate it.
I could not agree with you more, Gene. In fact, when I was at the PTO and these tools were shown to me, on improving disclosures, checking the claims to see if there's correspondence in the specification, to see the 112F limitations, to see if there's correspondence there. My answer was always, this is great to have an examiner do it, but really once the case is filed, the die is cast for the applicant. What I really want to see is the PTO encourage people on the outside to use these tools before the case is ever filed, because there's really nothing that the applicant can do, or not much an applicant can do once the case is filed. So this needs to be done in advance. And the second thing, which I have preached on many occasions, is that you're filing an application in the year 2025. That case is going to be litigated, the resulting patents, in 2035 to 2040. You're going to have to deal with whatever the 112 disclosure standards are in 2035 to 2040. And that's kind of difficult to predict. So you really need to have a sufficiently robust disclosure to satisfy any reasonable disclosure requirement that may be in existence when your patent comes up to be litigated.
Yeah, I think that's certainly true. Jim, any thoughts about from you? Because how does and I want to ask you to talk about AI more generally, but how does your system do this and improve this? And what kind of improvements and benefits and ROI do you get from using AI to tighten this up at the time of filing?
Sure. So we have aspects of our solution that allow you to evaluate enablement at the point in time where you have just an invention disclosure. So you can try to get ahead of any potential enablement rejections, which is a really important part of 112, trying to avoid that need for undue experimentation, which we sometimes see. We also have technologies to help pinpoint the exact points of novelty, or what the most unique parts of the invention are, and then focus on those in terms of making your specification more robust and drafting your claims, maybe even considering putting some of those limitations into an independent claim to shorten the prosecution cycle. So those are just some of the examples of the technologies that we have available today that can help with this problem.
Mm-hmm. Okay, so let me share the results from the last poll question here. And to what extent are you currently using AI to improve disclosure quality? We have 27% not using it at all. We have half of the audience that are experimenting with it. We have 13% that are, plotting with defined use cases. And then we have 8% that are operationalized across their IP-centric workflows. So we have the vast majority are either not using it or just kicking the tires with it. For the reasons we've said, I think that you do. I'm glad to see that so many people are either using it or at least kicking the tires. I think you have to be kicking the tires here on this. I think it will help. I think, Joe, you were the one that says this is like precisely the language type of things that AI does very well right now.
Exactly. Exactly. I can't imagine not using it in my daily activities. And I used to, in the olden days, to make sure my specifications were correct, I would usually start with a set of claims and then use those as the guide to write the specification to make sure that they were supported so nothing was left out. Well, now you can just take your entire document and run it through AI just to see, show me where these claims are supported in the specification. And again, if you're dealing with like somebody's trying to enforce a patent, this tool can work the same way too. They'll look at this patent and are these claims actually supported or not? Show me where they're supported. And it can go through so many documents so quickly that now you know what to look at. Just like with the semantic search, you know where to focus your attention as a human, as opposed to spending half your day just gathering materials to look at. So yeah, in terms of support for the claims, you really want to make sure your specification is well developed and that it makes sense, because you don't want to find out at the end of all this work you're not going to get your patent or it's not going to be enforceable. So
Yeah, yeah. So, Bob, since I have you here, let me ask you this, and I don't mean to put you on the spot here, so don't take this the wrong way, but examiners, including when they were quote unquote your examiners, as deputy commissioner for patent policy, you're the one who informs the examiners. I mean, you're like sort of their Sherpa, their leader, in a lot of ways. The one thing that just always frustrated me, and I've heard from a lot of other attorneys over time that have gotten more and more frustrated, they get these like 112 rejections from examiners, and then the attorney would say, but that's point to in the specification, write exactly where it is. And the examiner would say, but you only mentioned it once. And I do also think we've started seeing recently the Federal Circuit saying that same sort of thing. I don't know any support in the law for saying, well, you only mentioned it once, so that's really not a part of the invention. And I think what they're trying to say is, well, clearly the focus of the invention based on what you disclosed is X, not Y. And you're like, well, but I did disclose Y. Yeah, but you just did it like one time. I mean, and I bring this up now because it does strike me as the type of thing that AI might be able to be much better at helping you fix, to make sure that, well, whether we like it or not, it should be able to catch those things and say, you didn't emphasize this piece here, that piece there, type of thing. But what do you say about that? That a lot on the table.
Yeah, well, Gene, first of all, thank you for that question. I really, well, I appreciate what you said about me. I am concerned about being, I'll say, liable for every 112 rejection, just as much as I would be concerned about being liable for every 101 rejection or decision.
Well, no, but as
no,
I've told
I
you
get
before, and I've said before, you had the unenviable task of translating Federal Circuit into English so examiners could understand it, and I think you did a great job. It's not your responsibility. You're the messenger.
Right. I don't know about you can't be your invention because it was only mentioned once. I could see an examiner making a rejection about the breadth of the claim if you only mentioned one example and you had a broader claim in, say, an unpredictable art.
Sort of like
But
an Amgen type thing.
yeah, but I mean, I sort of see things being a mechanical engineer in a mechanical way is that most inventions are combinations of elements. So I don't know the fact that you only mention something once doesn't make it not part of your invention. But it I just have to see that case or to see
Right, right.
that line of reasoning.
Yeah. No, and that maybe was not a fair question without any more context to it.
Oh, that's fine, Gene.
No, but it does strike me that that is one type of thing that
hmm
I've heard people complain about, and I think if you're going to use AI, you might be able to catch that before. And so that I also think the people who are using AI, I think, are going to wind up having extremely robust applications, extremely robust filings. And I don't know what the Federal Circuit's going to ultimately do, but the trend seems pretty clear to me that whatever we do is not enough. I want to see them do that with some of these AI disclosures, because now from 50 years, 100 years ago, patents were 2 pages, 1 page of text, 1 page of drawings. 50 years ago, they were probably 4 or 5 pages. 20 years ago, they were probably 10 to 20 pages. Well, now there's no reason why they can't be as long and detailed as you can possibly imagine. And that also is going to slow down examiners in some ways. So any efficiencies that could be obtained through the use of AI, because the industry is using AI to get much more robust filings, is going to potentially slow down things. So it does feel a little bit like an arms race that's going on here now. Jim, does it feel that way to you, that, and I don't mean that in a necessarily pejorative way. It's just, like if we're using AI on the outside and the examiners are using AI on the inside, then you kind of are still hitting, you're roughly ratcheting up at the same level. But it also suggests that if you're not doing that, you're going to fall into the have not category pretty quickly.
Yeah, I think it's important to maintain that kind of parity. And as we discussed, as PTOs are already starting to leverage AI, it's going to become increasingly more important for corporations, TTOs, universities to use AI as well, even just to keep up. And you could imagine, to the point that Bob made a lot earlier, you need to be considering the 112 standards as they're going to be at the time you're litigating, which is so far into the future. What if AI actually plays a role in making the bar higher? Then that could become a problem for you. So I think that it's a pretty serious issue that you need to be using these tools to keep up.
Yeah.
I think there's another issue too,
Go
though.
ahead, Joe.
If you really understand the prior art, either from the USPTO's perspective or the inventor's perspective, the number of cases that will actually get filed will be reduced, because if the real understanding of the prior art, what is it? The issuance rate is 40%. So that means 60% of the applications that are filed had prior art issues or other issues. So if that could be dealt with early in the process, then this issue will go away in terms of pendency.
It may, but Rob, maybe you can talk to this. I think while it may be 40% on the first application, I think by the time you factor in the RCEs and the continuations, it's closer to 60 to 65%, right?
Yeah, it's much higher than that. In fact, just to clarify for AI, and I'll call it the filtering effect, you're probably not really filtering between the applications that are patentable and the applications that are not, but honing in on the subject matter that's ultimately patentable, because at the end of the day, more often than not, an application is going to be allowable. So when I was an examiner, in my mind, the trick was not so much figuring out how to reject the application, but figuring out what was the patentable subject matter, and getting to that point with the attorney as soon as possible. That's why I don't know that I see this so much as an arms race, but something that could work cooperatively, that you get the best prior art in the case as soon as possible. And that's what, if you will, you discuss or fight about. You're not constantly hopping from one set of references to a different set of references. So that's where I'm hoping that AI can improve the examination process.
Yeah. And this last poll question I asked about improving invention quality or invention disclosure quality, we have I'm a little surprised by this, but I mean, maybe it's not so surprising, because I think a lot of people do think that they do good jobs, and I think that you all do good jobs. And I think if you were doing this job that you were doing 20 years ago, it would be considered a fantastic job. I just think I probably would have answered at least major need or moderate need, simply because of where I see the courts heading. And then I also think what drives the courts to some extent is, like when you're a professor and you got a grade on a curve, and you look at high quality, high quality, high quality, and then something isn't so high quality, it sticks out. Now, and I think it sticks out in a way where, even if it technically meets what we would all agree are the standards, is not the same as what could have been done, because you see it over here. And I think there will be some of that goes into perceptions of decision makers moving forward. I could be wrong. Thoughts on this poll, gentlemen? Surprising, not surprising? No. Okay. No problem. We can stop sharing that one. And Jim, is there any more slides before the time gets away from us that you want?
There are a couple more if we could just go quickly.
Sure.
Wanted to mention that I mentioned this earlier. We have a semantic gist search engine. It's powered by natural language processing. It doesn't require Boolean knowledge. We're a secure and ITAR compliant company built entirely in the United States. And this is a semantic search engine, so it's not a type of generative AI, which means that it's completely free of hallucination. So that's one of the engines that underlies our IQ Ideas platform. If you go to the next slide. We also have a generative AI built into IQ Ideas called Compass AI that can use inventive principles to help you through a guided problem solving process. And this can help you when you're first coming up with your ideas, ideating, or you want to evaluate a new invention disclosure. Next slide. I want to talk a little bit about our patented novelty assessment scoring. So what we do is we have a way of normalizing the score to a baseline. Then we find the closest prior art from our system, and we measure the distance of it semantically in order to give an approximation for its novelty. So we give a score between 0 and 1,000, and there's a correlation between these semantic distances and novelty. So next slide. This is an example. For example, you see on the left where the semantic distance is high, you get a high novelty score. Whereas on the right, when the gap is smaller, you end up getting a lower novelty score. And this is comparing, once again, your idea to the closest prior art. And we have this system being deployed present day at some very large corporations in order to review their entire invention pipelines.
So, Jim,
yes.
can I ask you, what is self-match score?
That's a comparison of the query against itself. It's meant to normalize the score to remove any potential for bias. So it's a match of the search kind of against itself to use that as a basis to compare it against the closest prior art.
Okay, so it's sort of almost like a confidence.
Yeah, yeah, exactly.
Okay, all right, that makes sense. And then, okay, knockout. So this is the last poll question we have relates to knockouts. Do you want to talk a little bit about that before?
Sure. And this is our last slide here. I wanted to point out that you can ultimately produce a knockout report that helps you with novelty and obviousness considerations utilizing our software. It's divided based upon the points of novelty. So you can see how each of the individual novel points rank, as well as a ranking for the overall disclosure. And if you get a low score, we also want to mention that we sometimes advise our clients to consider defensively publishing with IP.com, which helps secure your freedom to operate in situations where you don't want a patent.
Okay, so let me launch that poll question that deals with knockouts here, and give you all an opportunity to chat about that. We have I can probably bring this question up. It looks like Chris is answering it in the Q&A box. But while folks do this, the question essentially is asked about using ChatGPT 5.0 to draft parts of applications and what our opinion is on that. I mean, my opinion would be very, very careful. I mean, I think that's for two reasons. One is you got to make sure you're using a tool that is not going to use your input for training. And so there's some versions of ChatGPT that you're fine with, and there's some versions that you're not fine with. So you got to make sure which version, what AI you're using, because that would be a per se violation of ethics, and clients would be upset to boot and all that. So there's a lot going on there. And then the other thing too is I just personally think what we need to be using are tools that are calibrated, for lack of a better way of saying it, but calibrated for our industry by people who understand our industry. So you have ChatGPT and Claude and Gemini and all these general AI tools. They're not patent calibrated. So they're gonna not be as good as a tool that has been put together by somebody that is trying to make the output patent appropriate. So what say you about ChatGPT, for example? Anyone? Jim, thoughts?
I think you have to be careful when you're using it for drafting for the reasons that you mentioned, but I do believe that those tools can potentially help assist with that sort of workflow in terms of helping you come up with good specification that's robust. But you need to be really careful about what version of, say, ChatGPT that you're using. So it's good to consider platforms like IP.com, where we have embedded within it LLMs that are secure and firewalled off, as well as our semantic gist search engine. I do believe that there's advantages to using that versus just a general purpose tool.
Yeah, I think that that's true as well. Joe, any comment? I know
Yeah,
you're power
I,
user.
Yeah, I always inform my my fellow engineers, please don't use Google patents because you're telling Google what you're interested in, what you're working on. It's not a closed system. Same thing with ChatGPT, unless you're using it within another framework where it's confidential, I think you're taking risks. But in terms of the tool's performance, well, it's inevitable that specifications will be written this way. It's just so much faster and so much more accurate, especially if a trained individual is using it. It's a force multiplier. But again, you can't just let it run wild on its own. You need to have somebody that knows what they're doing, controlling the system, or have the system within a controlled environment like IP.com.
Mhm. So Bob, any thoughts? It looks like you took yourself off mute, so I want to
Oh,
give you an opportunity.
Sure. The only thing I had to add here was that when I was at the PTO, which was a little bit more than 2 years ago, the instructions were basically with respect to these things. It's not no, but not now. Very cautious look for the reasons, Gene, you mentioned that it's an open system. You're giving your information away, and the PTO was very concerned about examiners putting their thoughts about an application, up for perusal. So I would imagine that if the PTO does go forward with these types of sophisticated AI, it will probably be some type of closed system.
Yeah. Yeah, I'm just rolling my eyes thinking, and I don't know why it had not dawned on me that, you have 8,500 to 9,000 examiners at any given time. I'm just like, oh my God, there's at least one of them at one point in time, no doubt, has gone to ChatGPT or somewhere. Uh, yeah, the risks are just enormous long term downstream, and some of these things you don't know until it really matters later. And a lot of times, a lot of these things you'll never know, like whether it was a provisional or whether it was an application that got abandoned or an application that didn't make any money. And so I think there's a lot of mistakes that are not forgiven but never discovered. Uh, so, but there's some liability out there around for everyone, I'm sure. So let me publish these results, and it looks like almost half say it has the benefit of faster go, no go decisions. There's some people focusing on the office action iteration and then the cost of searching. I would think if you gave people the opportunity to pick two or three, that those two or three would have run away with it. Because I think this is a situation where it's not all of the above because of the last answer, but most of the above, I think, are probably, depending upon what piece you're focusing on at the moment. Any surprises here, Jim?
No, I'm encouraged to see the top results kind of line up with my expectations, and hardly anyone said little or no benefit. So I think that's really great that people are exploring AIs in this fashion.
Yeah, yeah. And I would love to have a conversation with those people who say little or no benefit. I mean, I think we're starting to, because if we had had that conversation 10 years ago, for sure, 20 years ago, absolutely. There was an awful lot of people that just were not doing any searching and didn't want to search, and I don't want to know, and all that other sort of. I think, given the world we live in and how hard it has gotten to file these applications so they have 112 support, and then how hard it has gotten to get them issued, and then also how hard it is to keep a patent once it is issued, I think people have really clued into the benefit of why it is you want to be doing these searches. And it saves you resources because you're going to weed out a lot of things, and it makes what you do file better. So it's good to hear, good to see. So that's the last poll question that we have. So let me can probably stop sharing my screen here now as we wrap in, move to the final. Let's see, look at the time. We got about 5 minutes left. We could probably squeeze in one question here. One of the questions that we have that is still pending here is, what are your thoughts on the use and success of track one filing? This came up earlier on in the conversation when we were talking about that being one of the ways that you might have to deal with the patent backlog if you have something that you think really does matter. Obviously, you can't have everything go track one. There is a limit, although the office has never invoked that limit. But I think if you had several 100,000 or more people going track one, then they probably would have to invoke the limit. But Bob, what say you?
Okay. First of all, just to be clear, Gene, it's just the office isn't, to my knowledge, ever gone over the limit. What I've done is sort of, when petitions were filed in September and we were approaching the limit, we just hold off on granting them until October. So we just avoid,
Right.
saying no to someone because it hits that limit. And I think the limit currently was raised to about 20,000
I
applications.
think you're right.
And
It
like
was
you say, it's a
recently
fee of between 4,000 and 5,000. So it's a considerable fee. That acts as a self-limiter. But the PTO, at least when I was there, it did make a strong effort to get these cases done within the 1 year time frame. So if you have an important application, it's something worth thinking about. Also, one of the effects it has sometimes is if you are having difficulty with an examiner, it just might get the continuation of that case filed with the track one, moved to a different examiner. That has happened on occasion. Can't guarantee it, but it's something to consider.
and the allowance rate is at least 10% higher pretty much across the board.
It is. I frankly never thought that it was because examiners were more inclined to allow them. It probably is a combination of an applicant's more serious about the case, and so that probably is more likely to be allowable. And the examiner doing it has room on their docket, so they're a more, I'll call, decisive examiner. They're not someone who just rejects over and over again, because that type of examiner is going to have room on their docket for a track one case.
Right, right.
But that's just the
I
theory.
agree. I think there's a self-selecting nature there, and I
Yes.
also do think there's a perception, whether it's true or not, but that you get quote unquote better examiners, and better probably being defined by patent owner, more friendly, not and it's not like you're getting somebody who's always green lighting you. I mean, because the allowance rate across the board is on the order of somewhere between 55 and 60% in the right off the bat in the first case with no RCE or no continuation necessary. So it's not a green rubber stamp, straight to go kind of situation.
No, you're right. More often than not, it's the cases do get allowed. So
Yeah.
saying that you got a green light because of it, I don't think that's founded.
No, so I'm a fan of the track one, and one of the things that and I don't think I mentioned this while we were live, I mentioned in the ready room as we were getting ready to come on live today, was that I think with, again, patent prosecution laches in mind, I would rather get a patent issued within 6 years rather than over 6 years, just so I don't have to deal with that presumption, whatever happens once the Federal Circuit actually colors within the lines to tell us what those rules really are after we have enough cases. So if you have an important case and it's been pending like 4.5 years or so, you might want to think about filing a continuation and paying the track one so that you can get that within the 12 months, which should safely get you under the 6 years for at least something, at least something. But should it be that way? Probably shouldn't be that way. Is that way? Well, I personally think it is that way. And I think we need to eyes wide open, because how much would you pay for a patent that took 7 years to issue? Okay, now and I'm just asking it in a vacuum, would it be more or less than the same patent that took 5 years to issue? Well, in the world we live in right now with patent prosecution laches, you would pay less for the 7-year patent, everything being identical, because you have one extra hurdle to that patent being worth literally anything. And I think that this is an issue that the whole industry needs to keep their eyes on. But gentlemen, we're coming down, we're right at the top of the hour, but I'd like to give each of you an opportunity to give your final parting thoughts, and we can go in the order in which we were introduced. So Bob, why don't you give us your final thoughts here today? What do you hope people take away?
Sure. Well, I'm not going to represent myself as an expert in AI, but I'll just say that 200 years ago, the Erie Canal was built mostly with shovels and buckets. And along came a steam engine that powered a shovel, and people thought, oh my God, that will put everyone out of work. The reality is, that's how you're looking at AI today when you say, I don't want to use it. It's going to be used, it's just a matter of how. So I just think the important thing is to figure out how it works and to figure out how to use it safely.
Great, awesome. Thanks, Bob. Joe, your final message.
I think that assumed patentability is inversely proportional to knowledge of the prior art. And I think before you start spending any corporate resources, you really have to understand the prior art before you do anything. And that should be the earliest thing in the ideation process. As the ideas are being formed, that's when you should start understanding the prior art. And if you don't do that, you're just going to be throwing away corporate resources.
Yeah, no, absolutely. Thanks a lot, Joe. And Jim, the final word goes to you. What do you hope people leave today remembering?
I would just think about pendency very broadly and think about those areas where you can make a difference based upon applying AI tools in your practice. You think about reducing that time between first office action and the total pendency by having better claims, by having a better specification, and really do that work up front until it's too late to correct once it's already filed.
Awesome. Well, thank you guys. I really appreciate that. That was a great conversation. And thank you all for spending your lunchtime with us here on the East Coast, and for whatever time you are, wherever you're at. We really appreciate you watching, and we hope to see you again soon. But that's all we have for today. So bye for now, everybody.